Hello, everyone here and everyone who is joining or going to be watching this via Zoom. We are here today to be talking about marijuana law and how it affects businesses in Colorado with a particular focus on the construction industry. As most of you know, Galvanized Law Group is a firm that specializes in construction law and services, general contractors, subcontractors, anyone within the construction industry. We put on these lunch and learn series once a month to provide insight into different areas of the law. And today we're going to be talking about marijuana law. My name is Joseph Kiley. I'm an associate attorney at Galvanized Law Group. I've been with the firm since its inception and have been working within the construction industry law realm for the past 7 years or so. So let's just jump on into this. A few things that we're going to be going over today are issues related to what a business should do in terms of implementing marijuana policies and drug policies in general. Since Colorado has legalized marijuana and many other states are also in the process or have already legalized marijuana for both medicinal and recreational use, there can be some confusion in regard to what a business can do in terms of ensuring that employees do not abuse marijuana or show up on a job site while they're impaired. So one of the first things we're going to go over is just what can a business do in terms of regulating marijuana use within their business. Second question we're going to go over is whether a company in Colorado should implement drug testing programs. We'll also touch on the implications for an employer the implications for employers if an employee uses marijuana and there is an accident that could be associated with impairment based on the marijuana use. We'll go over some OSHA regulations, stances on marijuana, and then finally we'll touch on what happens if a Colorado company takes on a federal job. So as most people know, marijuana legalization is on the rise. The trends suggest that recreational marijuana is probably going to be legal across every state, probably within the next 10 years or so. There are that are reluctant to pass laws legalizing marijuana, but just looking at the trends, in 2010, there were 0 states that had legalized recreational marijuana. 2012, 2 states were the first to legalize recreational marijuana, Colorado being one of them. 6 years later, it's up to 9 states. 4 years after that, the amount has doubled to 18 states. So the trend is definitely towards legalization of marijuana recreational across every state. And because some states have legalized marijuana, some do not, there are different rules that apply to each state in regard to policies and procedures related to prohibiting marijuana within the workplace, when certain procedures can be done to implement drug testing, whether there are procedures in place where you can basically under what circumstances you are allowed to test employees for marijuana, whether the type of business that you're in has an implication on the policies that you can have in place related to marijuana, drug testing, and prohibition. There also comes in different considerations when thinking about how recreational marijuana compares to medical marijuana use. You might think because a drug is legalized for medical purposes that there are laws in place that protect use of that drug outright. But as we find out, that actually is not true, especially with respect to Colorado. And because marijuana is still illegal federally, it is not lawful to use whenever you want. And it's not a constitutional right to be able to smoke marijuana just because it's legal in the state that we're in. So the first question is, now that we know marijuana is legal in Colorado, can an employer still prohibit the use of marijuana? And the answer is yes. And as I just mentioned, the reason for that is because marijuana is still illegal under federal law. You know, if you want to have, you're allowed to have a policy in place that prohibits marijuana use in your business within Colorado, regardless of the fact that it is legal recreationally and medicinally. The reason for this is because it's still illegal under federal law. There was a landmark case that came down in I think it was around 2012. The case was decided. It's called Coates v. Dish Network. And this case involved a gentleman, Mr. Coates, who was a quadriplegic who was confined to a wheelchair since he was a teenager. Mr. Coates was working for Dish Network, and he had started that job in 2007. In 2009, after marijuana became legal for medicinal purposes, Mr. Coates was able to get a medical marijuana license, and he informed his company, Dish Network, that he was using medical marijuana. Dish Network had a company policy in place that prohibited any kind of drug use across the board. And it also had a policy that allowed for random drug testing. Mr. Coates, after informing the company that he had been using medical marijuana, was randomly drug tested. This was a year after he had been using medicinal marijuana. The random drug test showed up positive and he was terminated. Dish Network, he was terminated because he had violated the drug policy. Mr. Coates brought a wrongful termination lawsuit against Dish Network. He argued that Dish Network violated the unlawful prohibition of legal activities as a condition of employment statute. And that statute provides that it shall be a discriminatory or unfair employment practice for an employer to terminate the employment of an employee due to that employee's engaging in any lawful activity off the premises of the employer during non-working hours. So Mr. Coates argued that using medical marijuana was a lawful activity, and he was not using medical marijuana while he was at his job. Therefore, Dish Network was not permitted to terminate him simply based on positive tests. The case eventually made it to the Colorado Supreme Court, which determined that the definition of lawful is not just confined to state law. And again, because marijuana and marijuana use is unequivocally illegal under federal law, Dish Network was not in violation of the statute related to the unlawful prohibition of legal activities as a condition of employment. And so Dish Network was in the right to terminate Mr. Coates because he tested positive for marijuana. And that really set the precedent of there being, regardless of the legal status of marijuana within Colorado, an employer is still within its rights to prohibit employees from using marijuana. And if they have a policy in place prohibiting the use, an employee can be terminated regardless of the fact that marijuana is legal in Colorado. So that raises a few questions for employers. Since an employer is allowed to prohibit marijuana use by its employees, regardless of its legal status, you should ask if your company should have a policy in place to address marijuana use, and if so, what those policies should look like. And that's really where different states have differing laws in regard to what a company can and cannot do in order to regulate their employees' use of marijuana, especially off-duty use. I think it's pretty obvious that there can be policies in place that strictly prohibit impairment of marijuana while you're on the job. But really the questions come in when you consider using marijuana at night after a job, when you're going to a concert, whatnot. And marijuana is also a tricky drug in that testing for marijuana is very different than the majority of drugs because it stays in a person's system for a lot longer than other illicit drugs like cocaine or heroin. And we'll touch on that a little bit coming up. All right, so why would you want to have a policy that prohibits, regulates marijuana use? You might think that because the state has decided that marijuana is not so harmful that it should be legalized, you could think, well, okay, well then it's not that big of a deal. Why would I be concerned about marijuana use in my business? You know, there are a lot of stereotypes that are attached to people that use marijuana. A lot of those are probably less true than you would think. You know, in my personal experience with people I know that use marijuana, you know, some people have been able to use it for productive reasons. I had friends in law school who would smoke before going to class or before writing a paper, and somehow I don't understand how, but it would actually be a stimulant for them in some respects, and they were able to get a benefit from using the drug before doing something that required a lot of attention and required a lot of focus. On the other hand, some people have a minimal amount of marijuana ingested and they can't function at all. So there's a lot of leeway in how marijuana affects every person. And there are a lot of stereotypes that you do see are true. You know, it's pretty widely recognized that marijuana use, it decreases productivity. It certainly affects cognitive functions. For the most part, it affects cognitive functions in a negative way. I think my friend in law school was probably the outlier in that he was able to get a benefit from it. But if you're a business and you need to start deciding what you should do, you should err on the side of assuming that marijuana is going to have a detrimental effect on your employees. And this is particularly important in the construction industry because there are inherent risks that come with working a construction job. You know, unlike an accountant who is mostly sitting behind a desk all day or behind a computer, if they use marijuana before going into work, you know, they might fudge some numbers on a computer, but they aren't going to create a situation where a lapse in memory or focus is going to cause a potentially life-threatening accident, which can happen in the construction industry. So obviously, one of the major risks of having no policy in place for a construction company related to regulating drug use is that it can cause accidents, which will result in the company having to dedicate time and resources to investigating causes of these accidents, implementing drug testing programs. You could have situations where an accident causes destruction to equipment. And really the biggest concern is that marijuana use or impairment on a construction site will cause an accident that could subject the company to liability. So really the main focus here is trying to prevent accidents and injuries from occurring on the job site, which will cause your company to incur expenses in investigating, dealing with worker compensation claims, potentially getting OSHA involved. And once OSHA is involved, then your work site could be subject to investigations that could also crop up other issues that you might not have been expecting or OSHA wasn't even looking for. So it's a good idea to have policies in place to deal with marijuana use within your company. The last bullet point here also references potential public relations consequences based on workplace incidents. You know, because marijuana is a hot topic, any kind of media attention that involves marijuana is going to be amplified. There's a couple cases that received from some headline news within Denver in the last few years. In 2016, there was a gentleman working for an aluminum cutting company, and he fell into the aluminum cutter and died. The case got a whole lot of attention because while workplace accidents are not uncommon, after his autopsy came back, he found that marijuana, there was THC in his system, which raises the question of, okay, well, did the accident occur because he was potentially under the influence of marijuana at the time of the accident? And again, that brings up questions related to the drug testing and amount of time that marijuana stays in your system, because it's really difficult to tell whether at the time of a particular incident, someone was under the influence of alcohol, of marijuana. It's not like alcohol where you can take a breathalyzer and you can tell immediately that the person has 0.1% of blood alcohol level. Marijuana just doesn't work like that. There's another case with involving a ski accident where a person working for one of the resorts was killed in a ski accident, and he also had a massive amount of THC in his system, which had impacts on his ability to collect workers' compensation benefits, because there's a presumption in Colorado that if an accident occurs and marijuana is found in your drug system, there's a presumption that the accident was caused because you were under the influence of marijuana, even though you could have smoked or eaten some edibles, a week, 2 weeks prior. The fact that it's in your system, there's a presumption that an accident was caused because of that. So again, really the main reason you would want to have policies in place that regulate marijuana use is for safety. Really, there's no argument that can be made that marijuana consumption and impairment on the job, especially within construction, is not dangerous and cannot have the potential to cause accidents or injuries to either the person that is under the influence or has used marijuana or to other people on the job site. There's a general consensus that marijuana impairs your sensory perception, memory, motor skills, and judgment. All of these increase the chances of injury or accidents on a construction site. So no construction company would want to toe any line that could potentially expose the company to liability. Instead, regardless of the legal status of marijuana in Colorado, it should be treated like any other illegal drug. One potential negative of not having a clear policy in place related to drug use on and off the job relates to potential civil liability. If an employee causes an accident that injures another employee or a third party, a lawsuit is going to be inevitable. And plaintiffs' attorneys that are picking up these cases, they're going to do everything they can to establish that the company is responsible for creating an environment that was tolerant to drug use. And that will potentially lead to greater damages that could be assessed against the company. Some of them that likely would not be covered under an insurance policy. If we think about a situation where an apartment building is being constructed and a crane operator is under the influence of marijuana, somehow drops the load and it falls on an excavator beneath and then hits another employee that's standing by the work site, or maybe it's a bystander walking by that is injured. Well, now you have a situation where because marijuana is being used, you have an accident that's damaged equipment that you're going to have to replace. You have a employee that could either potentially be injured that would be filing a workers' compensation claim, or you have a bystander that would hire an attorney to bring any kind of suit they could against the company. Once a lawsuit's brought, that would open the company up to discovery. And let's say the attorney requests policies and procedures that are in place for the company related to drug policies. And let's say that your company has procedures in place, but they don't implement any of those. Now the plaintiff's attorney is going to come up with arguments that the company has created an environment that is tolerant to drug use and is basically creating an unsafe environment, even though they know that this is a risky arena based on the fact that they have drug policies in place that they don't actually implement, that could subject the company to punitive damages, exemplary damages, or potential negligent retention claims. And a lot of these would not be covered under a general liability policy. Another implication that comes into play is related to workers' compensation. The more accidents that occur, the higher your premiums for workers' compensation will be. So if you're not ensuring that your employees are following drug policies that you have in place, there's the potential for more accidents to occur, which will only increase the amount of insurance workers' compensation premiums that you're going to be assessed. Another thing that related to workers' compensation from the actual employee side has to do with benefits that you can or cannot receive if it's determined that you had marijuana in your system at the time of an injury. Going back to the ski case I was talking about, that gentleman who was killed in a ski accident while working for one of the resorts, because they found THC in his system at the autopsy, there was a presumption that he was under the influence of marijuana at the time of the incident. And because of that, the wage benefits that he would have received were cut in half. So that means his family, he had a wife and 3 kids, only got half the benefits they would have received had he not had THC in his system. And while there is ways you can try to demonstrate that, yes, I had THC in my system, but I wasn't impaired during the actual incident, you can make that argument, but you have to prove it by clear and convincing evidence, which is a extremely high bar to overcome. And especially with respect to this poor guy who was killed, there's really no way that an argument was going to be able to be raised that he was not impaired at the time, because the standard that they have to prove is clear and convincing evidence, which is almost impossible, especially if the person who is actually impaired is not there to testify or state his defense. There are also some states have laws in place. They're called drug-free workplace laws that provide workers' compensation discounts for businesses that have certain drug policies in place. And if you can show that you're a company that abides by these specific policies that are codified within the statutes of a particular state, the company is entitled to get discounts on their workers' compensation premiums. Unfortunately, Colorado does not have one of these laws, but it's still worth having a discussion with your workers' compensation carrier in regard to whether there are any kind of discounts that they would apply based on the type of procedures and policies that you have in place to prevent workers from using marijuana, again, on and off the job. Workers' compensation can also be a good resource to go to your workers' compensation carrier to provide materials that you can give out to your employees in order to explain to them the risks of marijuana use and the potential pitfalls that can arise if marijuana is a prevalent drug that's being used during or after working hours. One of the important things to remember is that you should have, it's highly recommended to have drug policies in place that provide clear rules related to drug testing and penalties that can be assessed against employees that violate the policies that you have in place. A question that is raised based on the legal status of marijuana in Colorado is, whether you are allowed to drug test your employees. And the answer to that is yes. Going back to the Coates v. Dish Network decision, because marijuana is still illegal federally, there's really nothing that can prevent a company from drug testing their employees, which is a good way to ensure that you're promoting a safe environment and an environment that is going to really limit the amount of risk and potential liability that your company can face. Here, and there was a bill that was introduced in the spring of 2022 that would restrict an employer from drug testing employees because it can be seen as a form of retaliation, and because the drug tests that are available to detect marijuana are not the best in determining actual impairment at a certain time, because marijuana stays in your system for so long. There were companies that were arguing, this is unfair, and because marijuana is legal, you shouldn't be able to limit someone's ability to get a job based on using something that is legal. Colorado legislature rejected this bill, and so an employee still has the ability to drug test their employees and have policies in place that say if marijuana is found in a drug test, then the employee can be terminated. It should be noted that if you are going to implement drug testing procedures, the company has to pay for that, and they have to do it at a testing facility or a licensed lab. You can't rely on a home test in order to test your employees. And really that comes down to accuracy of the test and giving the employee the ability to basically challenge the validity of a drug test. So we're going to talk quickly about the types of drug testing. First, pre-employment testing. I think this is probably one of the ones that companies should implement, because it's not only will it weed out potential employees that use marijuana too much and will have potential for coming onto a job impaired. It will also kind of help you vet employees that, you know, may not be as committed to the job as others. You know, if someone is a frequent marijuana user and wants to get a job with your company and they know they're going to have to get drug tested, you know, if they're willing to quit using the drug for a certain period of time, that's going to tell you this is someone that, you know, is probably someone I want to hire because I know that they're going to at least sacrifice a certain amount in order to get the job. And it kind of sets the stage for informing the employees that, you know, the company understands marijuana is legal in Colorado, but you're going to have to take the risk of being subjected to drug tests if you want to work at this company. Random testing is also another form of testing that's perfectly fine in Colorado, as long as it is actually being implemented on a random basis. We'll talk about in a second about retaliation claims and how some employers can use drug testing as a means to basically terminate an employee that they wouldn't have otherwise, or they don't have cause to, aside from the fact that they perhaps know that they use the drug and they can use a drug test as an excuse to fire the employee. Return to duty testing, this comes up after, let's say, an employee is injured, they take leave because they're on workers' compensation. They may have been using certain drugs to alleviate their pain. That could include medical marijuana. So return to duty testing is just after they come back from their leave, testing them again. Reasonable suspicion or cause testing. You know, a company should always be vigilant in watching their employees, monitoring their moods, looking for things that show signs of impairment. If you have, and you are allowed to test if you have a reasonable suspicion that someone is, you know, on the job impaired. But if you do have this kind of policy in place, it needs to be very clearly defined in your company policies, because again, this is an area where a lot of abuse could come to fruition if a company is just drug testing someone because they have an incentive to potentially fire that person. Follow-up testing, that's pretty self-explanatory. You could have a policy in place that, you know, if you could have a 3-strike policy, you know, if there's a random drug test that you fail, you could have a month in order to, you know, show that you're not under the influence of the drug anymore. That would fall under follow-up testing. And then post-accident testing is probably one of the most, I would say, controversial, but it comes with a lot of potential issues, especially as OSHA is concerned. And that really relates to the potential for retaliation claims being made based on post-accident testing. You know, you can't have a procedure in place that mandates across the board, if there's an accident, you're going to be drug tested. You know, any policy that you have has to be tailored to the specific incident that occurred and the testing has to be reasonable based on the accident and who might actually have been responsible for causing the accident due to the impairment being under the influence of the drug. So but yeah, as I mentioned, OSHA does not require mandatory drug testing, and it actually prohibits mandatory drug testing in some instances such as post-accident drug testing. If there is a procedure in place that just requires post-accident testing, regardless of the circumstances that are involved. OSHA recognizes that it's difficult to determine if an employee is impaired by marijuana at the time of an injury or accident, even if it shows up during a drug test, because again, marijuana metabolizes differently than other drugs and stays in their system a lot longer. So really the best practice is to have some kind of drug testing policy in place, but it has to be very well defined within your company policies. And you have to not just have a policy in place that's clearly defined and is communicated such that every employee knows the ins and outs of it, but you also have to enforce that policy. You can't just have it there and not actually follow it yourself as the company, because that would essentially that would be essentially the same thing as having no policy at all. And if you have a policy in place, there are certain defenses that you'd be able to raise if a OSHA violation is brought against you. But again, simply just having a policy in place isn't enough. You need to make sure that that policy, those rules, are communicated to employees and that you're actually implementing those policies. Touching on the OSHA's stance on retaliation claims and what kind of drug testing you can do if an accident occurs. Again, testing, it has to be reasonable under the circumstances. You cannot have a policy in place that requires automatic drug testing if an employee reports an injury, like let's say carpal tunnel. That's not a type of injury that is going to occur because a person was under the influence of, or potentially under the influence of marijuana. That's something that developed over a long period of time, and it's not going to be based on impairment alone. Going back to the crane example of, let's say the crane operator drops a load, injures someone below. In that situation, it could be reasonable to drug test the crane operator because being under the influence of marijuana may have affected his ability to operate the crane properly. It would also be reasonable to test the person who is in charge of hooking up the load to the crane, because if he was under the influence of marijuana, his abilities may have been impaired such that he didn't connect the load properly. But it would be unreasonable to test the poor guy that was standing below and that was injured by the crane load falling on him. If you test that guy, we'll call him Jerry, and he tests positive because he went to a Fish concert at Red Rocks a couple weeks before and had a couple edibles, a marijuana test would show up positive. And because there's a presumption that if marijuana shows up in your system, that you were under the influence of it at the time of the incident, he could be terminated if you have policies in place that prohibit drug use. But the fact of the matter is that individual who is just a bystander that gets injured, whether or not he was on marijuana, impaired by marijuana at the time, doesn't have an effect on the cause of the accident. And it would be potentially considered retaliation if you drug test him and then terminate him simply because he tested positive for marijuana, even though that had nothing to do with the fact that he was injured at all. So really the main takeaway for this for companies is that, it's good practice to have a drug testing policy in place, but it needs to be clearly defined and needs to be clearly communicated to employees. You should provide training and education to your employees in regard to the effects that marijuana can have, whether you're using it on the job or off the job. It's you may not think that there can be any kind of hangover effect or impairment after hours of using the drug, but there are still effects that can linger, that can cause risk of job site accidents that should be communicated to your employees. It's also beneficial to provide training to employees just about abuse issues, drug issues in general. There are helplines and treatment centers available that you should, as a company, be looking after your employees, especially in the construction industry, which has one of the higher rates of substance abuse than other industries. And again, workers' compensation, your carrier for workers' compensation, they are normally a good source to go to that will have resources that you can utilize and provide to your employees. Also, you should try to keep updated with all the current laws, as marijuana becomes more prevalent, laws change. This is a new arena, so it's always good to keep up to date on what the new regulations are. And you should have a policy in place related specifically to medical marijuana. Because again, you can prohibit the use of any type of marijuana, but there are situations where you could have policies that are more lax towards medical use as opposed to simply recreational use. All right, let's touch quickly on federal projects. Again, marijuana is illegal federally, and there are laws in place that if you're bidding on a federal job, there's enacts absolute prohibition against any kind of marijuana use, and you as a company need to make sure that you are having policies that abide with the federal rules. And this is really another reason it's good to just have a marijuana policy, prevention policy in place in general, because if you're ever going to be bidding on a federal job, you're gonna have to put these procedures in place anyways. So, if you're a company trying to grow, trying to move beyond Colorado, you should have these policies in place, just because they're eventually going to come up anyways. Yeah, as I just mentioned, under federal law, employers are required to provide a workplace free from recognized hazards. Marijuana is strictly prohibited. If you have any kind of, if your business involves any kind of shipping, or you have any employees that have commercial driver's license, the Department of Transportation requires all businesses operating commercial vehicles interstate to have a drug-free workplace as well. Really, if you're crossing state lines in any way, you're going to get into that federal mandated, regulated area. So you should have these kind of policies in place. Touching back on to OSHA, OSHA has a general duty clause that requires employers to furnish a place of employment which are free from recognized hazards that are causing or likely to cause death or serious physical harm to employees. There's an argument that can be raised that if you are a company that is not implementing drug policies, that you're creating an environment that is hazardous and has the potential to cause physical harm to employees or others. So you could be in violation of this general duty clause, which will just subject you to potential OSHA violations, which again will subject you to OSHA investigations that can lead to other issues potentially unrelated to drug violations at all. OSHA violations, these are, as you can see, pretty hefty fines that you can incur if you're in violation of this general duty clause, or if you're promoting an environment where accidents are likely to happen. There's also defenses that can be raised if you are hit with an OSHA violation, which it's called the unforeseeable employee misconduct defense. In order for this to apply, though, you must have a safety rule in place aimed at preventing a violation, preventing an injury or accident. In relation to drugs, you'd have to have a policy in place prohibiting drug use, requiring certain kind of testing procedures. And again, all these have to be clearly communicated to your employees. In order for this defense to apply, you have to demonstrate that the company provides all kind of training related to the safety rule that's in place. Not only that, but you have to not just provide training, but also ensure that the training that you're providing is being implemented on the job by inspecting job sites, making sure that employees are not showing up impaired to the job. recognizing the risks of, or the signs that someone might be impaired. And again, you have to effectively administer discipline to employees for their violations. You can't have rules in place that are not implemented, because that's rules without teeth are really just no rules at all. So in general, it may seem unreasonable to have a blanket prohibition against marijuana use, especially in Colorado, where it's so prevalent, it's legal. But you should have some policies in place in order to protect your company from the potential risks involved. And a lot of that is just communication with employees and watching employees, making sure they're not doing anything that would suggest that they're coming to the job stoned, or allowing other people to get away with getting high before a job. One of the things that kind of sparked this presentation for me was, I'll go on a run sometimes in the morning before work. There's a lot of construction going on where I live, and I'll run by a car that smells suspiciously like some plant is burning in there. And I always wonder, I wonder what that guy is doing on this apartment building that's being raised. I hope he's not the crane operator. I hope he's only using a hammer and nails. But as a company, you should be diligent in watching for signs of impairment, having these policies in place, making sure every employee understands them. Within the construction industry, it's also important to provide any kind of training or materials in Spanish, because if you have an employee that doesn't speak English, giving him a manual on these issues is really not going to be too helpful if he cannot understand them. And again, training your employees is vital. And with that, I think we're wrapped up here. If anyone has any questions.
Do you have any questions? There's a lot.
No pressure, don't worry.
Yeah, we have a policy. It's been in place for 15 years. Probably needs to be updated at this point, but having a policy that we have more liability.
That's a great question, and I think it would, yes, because if you do have a policy in place, that creates the optics that you're following this policy. And in the example I gave earlier of a bystander getting injured, if they hire an attorney, the attorney is going to dig through everything that this company has. They'll find your drug policy. Then they'll be in a deposition and ask you, okay, well, how do you implement this policy? How do you implement this policy? And if you don't have answers to those questions, they're going to raise the argument of, well, this is just a facade, and they're creating the impression of a safe work environment that really they're not sticking to at all, which could lead to additional liability.
Right now, I have employees who's worked here for 15 years. Change our policy. Use our policy or not have a policy. And now, like, marijuana tolerant.
Does your policy have a pre-employment? And always implement that? And if he's been there 15 years, then he's probably grandfathered in from that, and there's reasonable suspicion, if you haven't had that. I mean, that's how I'd answer that position. I didn't have reasonable suspicion this person used. And, you know, so we didn't drug test it.
I need to revisit that policy. Locking it back, so I want to make sure I'm taking out the liability. Now, I'm sure not be restricted in things. All right.
Yeah, especially on federal projects. That's the tough part. But there's a lot of risk. I mean, I think Joe had mentioned before the presentation that if, you know, you kind of get caught in a federal project using marijuana, you could be blacklisted from all future federal projects, and that's a good source of revenue for a lot of contractors.
Yeah, so it's about 10 years ago, we were in the hospital on that project.
Okay.
They essentially field testing. So, yeah, tested every single quality on site.
Really? At the VA, they had a marijuana testing mobile facility.
Actually, general contractor, never, he would implemented it on itself. It was better than that. Essentially, it happened. Next day, 30% of workers would come back, which would be tough to do nowadays because it's hard to plan. Show up for.
Well, and
That's why as an employer,
Wow.
choosing to weigh cost benefit of like essentially hire the best people out there because they go to fish concert once a month.
well, and that's really that's the balancing act you have to do, because, you know, we are in a time right now where there are labor shortages, and it could be seen as a competitive disadvantage to have these stringent drug policies. But, you know, you could be hit with that one catastrophic accident where marijuana is found in this guy's system, and, you know, general liability insurance will only cover so much. But, you know, that's why I think it's important to have, it sounds like you have policies in place, and it's just a matter of maybe wording them in such a way that, you know, you really emphasize the reasonable suspicion aspect of it. And if you don't have reasonable suspicion, then, you know, you can't really get docked for not implementing a policy if you've never really had reasonable suspicion to drug test this employee to begin with. And I think if that catastrophic accident did happen, and if you get hit with some kind of OSHA violation, you know, you can use that unforeseeable employee misconduct defense and say, hey, you know, these are our policies. We have them in place. I didn't know. I took the steps that I needed to as an employer to make sure that we have a safe environment. And I didn't know that this guy was going to cause an accident because I've implemented these policies.
I would say it's the same for contract defense. If the federal government, for example, said you don't get any monies for our VA project anymore because one of your guys tested hot, you could potentially say, hey, look, here's my drug policy. We didn't have reasonable suspicion this person was using, and we had policies in place to prevent that from happening. So we've taken care of that employee, but we're able to continue on working. Here's what we've done. You know, I think that would serve as a valid contract defense too. They try to terminate. So things to think about. That's the hard part. Is lawyers. My wife reminds me all the time. We think like lawyers. We think like risk managers, but we don't think like business people. We're reverse engineered almost from thinking like business people in a lot of ways. So a lot of it's, you know, business judgment and how do you run a business while you're dealing with a law. And sometimes they don't necessarily coincide in a way that allows for you to do business and comply with the law. So then you got to figure out what kind of risk you're able to handle while moving forward. You know, and that's the hard part of building business.
A lot of the government contracts situations that was recently are to show a negative test. So it's almost like requirements.
And that's another, like,
Like, okay, we got a contract coming up in 2 months.
Yeah.
What-
Everybody know what he wants.
That's it.
yeah. Well, and I think they like laws generally federally everywhere are getting more lenient because, you know, the writing's on the wall where I think Biden made some statement a couple weeks ago that, you know, we're really pushing towards, you know, being legal federally. But there's always the chance that, you know, you get hit with a violation, and if you get a judge who's potentially not lenient, then, you know, you're still potentially liable. And right now there is really, there is uncertainty, which bright line rules I think are better for society in general. Gray areas are better for attorneys because that means we get to argue things. But, you know, that's the environment we're in. Hopefully it'll change soon. For you, I would say, really for you and any business, and especially construction businesses, not even with respect to implementing drug policies, but just any kind of work in general, is document everything you can. You know, if you're have your policies in place and then document the efforts that you're making to ensure that those policies are enforced. Because then if you do get into a situation where you have to explain yourself, it's not just a person sitting up there saying, oh, well, yeah, we do this and we do that. You can say, oh, we did this and we did that. Here's the, you know, inspection that we did in 2014 where we, you know, went to the job site, made sure everyone didn't show any signs of impairment or whatnot. Having that paper trail is always huge when it comes to defending yourself.
Yeah, thanks, Joe.
Yeah, you're welcome. I hope you got something out of it.